The ACC files an appeal in Florida, and we finally know how the ACC vote went down.
The ACC lawsuits are always in the news, so we're back on the big mountain to break it down for you.
Hey, good to have you back on the mountain. I'm JY, and this is my good friend Steve. Had some big news coming out the end of last week. We want to talk about that. Before I get into the appeal, Steve, we finally get the minutes of the infamous meeting in which 12 ACC schools voted in favor of litigation against FSU. Yes, there's actual minutes.
Oh.
So stop with all these conspiracy theories.
What's 5 months later, right?
Yeah, I don't know. I will say it was stupid how long it took for somebody to see these things. But we all know, well, we knew they were going to be there. So we finally see them. The vote was unanimous, 12-0. And you say 12, there's 15 members.
Yeah.
Well, obviously we knew that FSU didn't get an invite to litigate against themselves.
Yeah.
So we knew that. We also knew Clemson did not vote or did not attend the vote. There was a mysterious third party. We weren't sure who it was. We now know UNC also did not attend the vote. So those are the three that weren't there, but the other 12 voted, again, unanimously for litigation against FSU. So let's put that sucker to bed. Finally, we can answer that. No more conspiracy theories.
Before we put it to bed,
okay.
I want to bubble up the conspiracies a little bit.
Okay.
UNC being that third school that didn't vote, I think is interesting.
So they say it was because there was, the voting member was on their way out. I think it was day one of the new, and I don't remember the names of them. I'm sure we have some commenters that can correct me on who this is. But there was a transition there where the voting member for UNC was leaving. There was a new voting member. This was day one of them being in that position. So they say it's because, well, it was a new person. They couldn't attend the meeting and yada yada. Is that the case or not? Who knows? But they didn't show up.
Yeah, and so they say, and if we hop back in our big mountain time machine back to that time period of this was January, correct?
When they did the vote.
When they did the vote,
right, yeah.
There was all of those. There was a lot of rumor and speculation that UNC could be that third school looking to leave. There were some different quotes. That was before, I believe. Again, the big mountain time machine's not failing me here, I don't think, but I believe that was before the North Carolina Board of Governors came and laid down the law.
Correct.
So I find that interesting.
Yeah, it is interesting. A lot of interesting things. So let's get into the appeal. So on June 5th. Last week, the ACC filed a petition of writ of certiorari. I'm getting good at these words because we say them several times. Yeah. With the First District Court of Appeal in the state of Florida. In their very opening paragraph, the ACC claims that the trial court, which would be Judge Cooper's court, committed a judicial foul as it ignored the court's binding precedent of priority that requires a stay in this case pending the disposition in North Carolina. Instead, the trial court disclaimed its application and reverse-engineered its own rules to keep this case going in Tallahassee courts. The trial court's jettisoning of the principle of priority in favor of this manufactured novel approach that exists nowhere in Florida law trades decisional certainty for decisional chaos. We've said that many a times now. The ACC likes to say there's going to be chaos if there's multiple courts basically hearing and then potentially ruling on the same daggone document. The trial court's failure to apply this principle is the epitome of departure from the essential requirements of law, creating the irreparable harm that is required for a writ of certiorari. They then go through about 25 pages of background for this appeal. I'm not going to do that. We've gone over that many, many times. Nothing real new, but they lay out to the appeals court what's going on here, the parties and all that kind of jazz. They then get into their argument. So there's three different ones here I'm going to break down. The first one is Florida's principle of priority is well established. Florida is a strict priority jurisdiction, meaning that Florida grants priority to the first serve action and stays the Florida action when it is a later action, which is exactly what's happening here. The appeals court has held that principle of comity dictate the court in which jurisdiction first attaches should be given priority regarding adjudication of the case. Again, here, that would be North Carolina. Number 2, the trial court's refusal to stay this case works an irreparable harm. Now, to be clear, they have to show there's an irreparable harm here, again, to issue this writ of certiorari, so that's what they're doing here. But this court has held that even the mere possibility of inconsistent ruling amongst different courts adjudicating related lawsuits constitutes a harm which is material to the suit and for which there is no possibility of remedying this on appeal. They point out then that the Florida and North Carolina courts have already reached inconsistent rulings. They point out, number 1, whether FSU has actually waived sovereign immunity in North Carolina. Number 2, whether the ACC's action constitutes an anticipatory filing. And number 3, whether the North Carolina court properly applied the 10-factor test when it denied the motion to stay there in North Carolina. Their third argument is the trial court's denial of a priority-based stay departs from the essential requirements of law. They are, 1, failed to apply the principle of priority and limiting its inquiry into whether the cases are substantially similar and where jurisdiction is first attached. 2, manufacturing instead an alternate and novel balancing test with no basis in Florida law. And 3, reaching an incorrect legal conclusion based on this new and novel test that Judge Cooper, they say, came up with. Specifically, the trial court ruled in favor of FSU in that the ACC's action was a preemptive suit that smells of forum shopping. And they put that in quotes. I'm assuming that came directly out of the written order that Judge Cooper gave. Again, preemptive suit that smells of forum shopping. Despite this conclusion, the trial court did not cite any supporting Florida case law that any of the factors it considered extraordinary were in fact exceptional under Florida law. In fact, the ACC cites a case from the 3rd District in Florida that ruled an anticipatory suit should not divest the plaintiff of the choice of forum. Also, no Florida court has held that the trial court's discretion extends to creating new classes of exceptional circumstances based on the substance of the case. Rather, they routinely squash orders where a trial court abused its discretion by denying priority-based stays. Lastly, the conclusion by the trial court here was incorrect because the North Carolina action is not forum shopping under Florida law. There is nothing tenuous about the ACC's connection to North Carolina, and the North Carolina court concluded that North Carolina action was not forum shopping. Also, federal courts on which the trial court relied do not recognize this as an anticipatory filing. And again, the trial court offered no factual or legal basis for its statement that the ACC was forum shopping. In conclusion, they state that a priority-based stay is required pending disposition of the NC action. Before I throw it to you, I just want to say I'm reading this as they have it written in their motion, and of course they're attaching past legal precedents, past legal case law to a lot of what they're saying. This isn't them just bloviating on things. There's a lot of case law that they're citing this. I don't get into that. I don't say, well, it's this case and that case. But trust me, it's there. They're not just making this stuff up. So I know my opinion on where this is at, Steve. I'll throw it to you, and let's have a discussion on this.
Yeah, I think this is just another step in the continuing theme of both sides really trying to get their preferred venue and really fighting hard. We've seen this back and forth, both in North Carolina. and in Florida, and now we have that extra wild card of Pickens County in South Carolina.
Yeah.
So none of this surprises me. Again, it's a lot of the same similar themes, and I will say, I think, and we've talked about this before, adding their first point about creating chaos. I think to me, I think that's probably their strongest argument is the creating chaos, and it's now much stronger with Clemson entering the mix.
Yes.
So we'll see how that goes. That's something to keep keep looking at. And then also we talked about in a recent episode where with the Clemson case, where Clemson filed first and the ACC was second, and the ACC is kind of using some conflicting arguments in different states and in different situations depending on what's happened, which obviously they can do that.
Yep.
And it makes them they don't look so they don't look like hypocrites because they can cite some examples in Florida law.
Right.
So that kind of allows them, they can look in South Carolina law, they can look at North Carolina law, they can look at Florida law. And as long as they're using and citing real examples, I think it kind of shields them from being hypocritical.
Absolutely.
If anyone's looking at it that way.
Yeah.
So anyways, again, I think it the same continuing themes. We'll see how it goes. I spent a lot of time listening to Judge Cooper work his way through before he got to his written order. To me, in Judge Cooper's mind, he says it's forum shopping. We'll see, what the appeals court thinks of that.
Right.
To him, it was very clear when, in his written order, when he says the smells of forum shopping.
Yes.
Forum shopping. But a bigger part was, in this case, to me, the argument that he seemed to be tracking on was the whole sovereign immunity, the fact that the state of Florida has a major interest in this case because it's a public university, so it obviously should be Leon County is the forum, the natural forum for this. He made some arguments or some suggestions of that. Now, what I do think is, kind of interesting there is, again, we get back to that chaos theory, and do we get another state? Do we get another school? I think there's already, basically looking down the road, how chaotic can this be? Now, they made that example. The one example they used I thought was interesting was the sovereign immunity piece, because I love to come back to sovereign immunity.
Well, when I saw that, there's Steve.
Yeah, well, they made that argument, and and I think that argument. I really think the chaos argument helps them, but I think using this sovereign immunity example may not be the best example for them to help them in Florida, because they're right. What if we get, and we asked Doug Rohan this whenever he was on here, what if we get different judgments in different states that are saying different things? And Doug's answer was, we'll never get that far. It'll be just figured out before then. Mm-hmm. But I think that sovereign immunity piece, they're already pointing out, well, in North Carolina, we've had a ruling on sovereign immunity, and it's completely different than what a court in Florida said. So I think that might actually give an appeals court in Florida, it may damage their argument. I think they have a strong argument with the chaos theory, but the sovereign immunity piece is maybe kind of burst their bubble a little bit, or brings that back down to earth a little bit, because they're already pointing out, well, sovereign immunity, this is a public institution in the state of Florida, and we've already seen that North Carolina court has ruled against Florida State on the sovereign immunity piece. So that might be a part where an appeals court says, well, they're right, maybe they don't have all the normal factors, but this case is extraordinary. Because they said here that the judge didn't make any examples of it being extraordinary. Right. That might be the extraordinary piece, because this is a public university, a public entity, and the ideas of sovereign immunity are so important in this case.
Yeah, good points. I think the fact that, they really hammered home this whole novel manufactured approach. As we've said before, courts, judges like to use statutes and then case law to back it up.
Yep.
And just say, hey, here's the practice of the statute. And the ACC is just pounding Judge Cooper, not really with his decision, but he's not backing it up with proper case law. At least that's what they're saying, and they're saying why that is. I mean, they are nailing him on that. The other thing I would say is you brought up the chaos. I totally agree, and we've heard that the more parties that come in, not just FSU, but now we have FSU and Clemson. Yep. It's maybe more likely that it does now consolidate around North Carolina. And the reason I also say that, now I don't know what Pickens County is going to say to all this, but if it's going to be kind of based on priority of a lawsuit of the same document asking the same things, the priority was set in North Carolina with the very first case. I mean, that's what the ACC is going to say. Again, I don't know if that'll hold water in South Carolina or not. It absolutely is going to hold water in North Carolina, and they're going full speed ahead with this sucker. But yes, the chaos piece is very interesting and very important.
Yeah, and it just that keeps getting stronger. The fact of Clemson entering the mix gets stronger. It would get even stronger. Let's say, I'm just going to throw out an example.
Yeah.
Let's say Pitt, from Pennsylvania, that's a public institution. If they were going to get an invite to the Big 12 and they wanted to leave,
right.
Now we'd have 3 states. So I think the more states that get involved in this, the stronger that argument comes into play. Now, I don't necessarily think that the more likely it gets consolidated in North Carolina. I think the arguments get stronger, but the pullback the other way, and again, I love the sovereign immunity piece, is the more public institutions get involved, I think also the more likely that a state, Florida or South Carolina, says, no, this is a public institution.
Yeah.
We are going to hold this case and make this decision in our state. So I think that it can go either way.
And that's where comedy comes in. I didn't really talk. I think I mentioned it once in my write-up, but that's where comedy comes in, and that being basically when one court rules, there's supposed to be this principle that all other courts will abide by that ruling.
Right.
So they're using this chaos, this comedy, they're using all of this as this priority was already set. We have to do it in one jurisdiction here. And Cooper kind of was saying, well, he kind of thought the correct jurisdiction was in Florida. It wasn't Tallahassee. We had that question of, well, who is the correct plaintiff here? He would probably, I think his opinion is that FSU is the plaintiff here. Clearly, we know what Judge Bledsoe said in North Carolina. He thinks, again, it's about who's the daggone plaintiff, who's the correct plaintiff. So lots of crazy stuff going on. And the other piece there that the ACC mentioned with the Clemson piece is just the misdirection is what they brought up in terms of the priority argument with that. I'm anxious to see, I think moving forward right now, I'm anxious to see where we head with the Clemson and ACC filing in terms of priority and whether or not Judge Bledsoe agrees with misdirection and how he views this priority, because the shoe is on the other foot.
Yes.
To me, that's the most interesting part right now is that priority piece for the Clemson filing.
It causes the ACC to have to argue both sides but in different cases.
And they are, but will it hold water for the judge?
Right.
I don't know. Good stuff there. The last thing I want to mention is a motion to dismiss. Also on June 5th, the ACC filed their motion to dismiss the second amended complaint filed by FSU. Not going to go into this much detail. Of course, we knew this was coming. The second amended complaint had just come out about a week ago. Of course, they're going to motion to dismiss this thing. They again say it lacks jurisdiction. That's the reason it got dismissed in the beginning with an amendment allowed, and they beefed up their whole jurisdiction argument substantially. FSU did, but again, the ACC saying nope, the state of Florida lacks jurisdiction. They state that the ACC does not fall within the long-arm statutes provisions. I'm not going to get into the detail, but that was one of the items that FSU brought up to say, yeah, you do have jurisdiction here. One of them being the long-arm statute, and of course the ACC saying, nope, we don't fall within that. So we'll see how that plays. Their second reasoning is that there is a lack of rightness to challenge the withdrawal penalty. The declaration as to the withdrawal penalty is only hypothetical in nature right now, meaning I think that what their argument is, if they would have withdrawn and now we're pissing about what is the correct amount, now it's right because they've withdrawn, we don't agree on the amount, But what the ACC is saying, no, they want a declaration on a what if.
Yes.
And they're saying that's hypothetical. It's not ripe enough for that. Interesting. We'll see how that plays. And then they move to dismiss many of the counts because FSU has failed to state a cause of action, very similar to their first motion to dismiss. So I just wanted to add that on there. That was another filing they put forth in Leon County following up the second amended complaint. So good discussion, Steve. Anything else you want to add?
I have a big picture thought here.
Okay.
There's a lot of debate out there, and we've had different people on our show, and there's a lot of debate out there about a settlement and if we're close to a settlement, and people feel strongly one way or the other. That obviously the ACC isn't going to settle because they held all the cards,
right.
or some people feel the other way, that obviously as more schools are suing to potentially get out, the ACC is going to have to settle, whatever. You and I said from the very beginning when these cases first started that first battle, okay, over the venue and over the forum was going to be so important. And really, here we are in June, and that battle has not finished yet.
No, not at all.
So for me, I think these filings, and if the ACC could get the ruling that they're looking for in Florida and have this kicked over to North Carolina, or if we get some other rulings that go the other way, where it looks like maybe we're going to have 3 different cases in 3 different states. I think those are actually some things, because we saw this in the PAC before, where nobody was ready to settle, everybody was dug in, and then one side got a couple really just procedural losses. Like they weren't major losses other than kind of procedural losses that were going to shape how the case was going to go. And once you get a couple victories, 1 or 2 victories on one side, all of a sudden the other side is ready to come and settle and negotiate. Yep. So, it's huge. A lot of fans, a lot of just spectators out there might be, why do we care so much? Is this going to be in North Carolina? Is it going to be here or there? That is the first major battle of this war. Mm-hmm. And it might be enough if we get that battle settled and it's either going to, help one side or the other. That might be enough to get the different sides, basically somebody to kind of give in a little bit, because that's what a settlement is about.
Yep.
They're this far apart. You need somebody that's willing to give in and move towards the other position.
Right.
And so if that happens, we may be actually very close to a settlement and not know it until we know it, kind of thing. That's the thing, is it doesn't look like you're close to a settlement until all of a sudden you are. So just an overall thought, big picture of the case.
Yeah.
But either way, we're going to keep following this, because I think every single filing, it's chess moves.
Yeah.
It's moving your pawn, moving your rook, moving your bishop back and forth. They're chess moves trying to put pressure on the other side. And once enough pressure builds up one way or the other, we may see the case end suddenly.
Yeah. So I saw several. I meant to say this earlier. I saw several lawyers comment on this filing, and I have seen lots of glowing remarks from all sides. They're like, "Wow, this is a really well written filing by the ACC." Well written doesn't mean the judge is going to approve it, but I know they definitely. Again, I've seen several commenters that have said this was very well done by the ACC. And the other thing I will just say, I mentioned, to me right now, I'm really interested in the Clemson, the North Carolina piece with Clemson, to see where priority's at. The other one for me right now is this appeal with in the state of Florida, because that's big. If what the ACC is saying here really can carry weight with an appeals court, and they kind of go back and be like, yeah, Cooper, this is novel. That's not how we do things. I'm not going to say that is going to happen.
Right.
I think there's a lot of reasons it won't happen, but this is a big one too. I don't think the appeal in North Carolina is going to do much. FSU's not going to win that, in my opinion. FSU's not going to win that appeal in North Carolina. I don't really care too much about it, because my opinion's already made up on that. But the Clemson priority piece and this appeal in Florida, to me, are the 2 big items right now that we got going on.
Yeah, and again, it goes back to that issue of where this is going to ultimately play out. We've really seen, Judge Bledsoe has laid out in both of these cases, I think, exactly his thoughts on that.
Yep.
I don't see any surprises coming here.
Right.
If if a Florida Court of Appeals would overrule Judge Cooper, that would be a massive change. And there's more. I think there's more room for that. We'll see what happens.
Right. Yeah, well said.
I wanted to add one last thing. I've been doing some research on Leon County. Okay, why is this case in Leon County? Some people have said, hey, any case that affects the state of Florida, if you're suing the state of Florida, the governor, the AG, whatever, it has to take place in Leon County, which is just outside of Tallahassee, or surrounds Tallahassee, depending on how their counties are set up. So I've been looking into that, and I haven't necessarily found a statute in that, but it seems like, yes, that is indeed the precedent, that any cases, it's basically the de facto court in any cases that affect the state government, a state entity, that is basically, that there's a lot of precedent in the state of Florida that is basically the natural place. And I have not been able to find. So if someone has a Florida law or statute, please let us know. We've had a lot of questions about that, and I wanted to address it. I've looked into it, and yes, that is obviously the de facto court for all of these cases, but I can't exactly find if there's a law or statute for that.
Okay, good stuff. Hey, we thank you guys for watching this episode. Make sure you give it a like. Subscribe if you like our content. If you're new here, we have been on the FSU ACC lawsuit from the very beginning, and we are going to stay on it. We typically do at least one episode a week, it seems like. It depends on filings, but every time I'm like, there's not going to be many filings this week, something comes out. So anyway, hey, we thank you guys for watching, and we'll see you next time on The Big Mountain.